So we're going to spend a few minutes. I mean, taxes, when I first started doing workshops, which goes back almost 16 years now, is 1999. It's almost 17 years, actually, right? Taxes and estate taxes was enemy number one. Back in those days, as ancient as it was now, the estate tax exemption in New York, when I started, was $600,000 per person. We are now at a much higher level. So, but notwithstanding that estate taxes applies to relatively few people, it's important you understand it so then we can shift back to our focus on more of the personal planning goals that really affects everybody.
Yeah, even though I could sit here and tell you, look, taxes just aren't that big of a deal anymore when it comes to estate taxes, chances are you're probably going to want to know what I mean when I say that, which is why we go through this. Because taxes, of course, are a concern that a lot of people have.
So what's the real story with estate and gift tax?
Here's the real story.
So let's hear about gift taxes first.
Yeah. Where we start with this is that the government taxes us on the privilege of transferring assets, giving them to somebody else. It's a tax on the privilege of the transfer. It's not a tax on the money itself. Technically, legally, a tax on the money itself would be unconstitutional, which is why the government slick lawyers say that it's a tax on the privilege of the transfer. Back in 1916, when they first passed the estate tax laws, that was the answer, basically, when there were constitutional challenges. So how do we see this? So during lifetime, it's not estate, but it's the gift tax that we could potentially run into. Probably not, but it's there. So first off, why don't we see this every day? When we give a nice gift to somebody or make any kind of other transfer, you're allowed to give up to $14,000 per person per year without it even showing up on the government's radar. It literally is not considered a gift in the IRS's language. So I might give Megan $14,000 and she would say, "Thank you, Austin, for that nice gift." And I'd say, "You're welcome," because I know what she means because I'm a real person. But let's say Rich is with the IRS, he'd look at that and say, "Wait a minute, I didn't even see a gift." Because in the language of the IRS, anything that's $14,000 or under per person per year is just not even considered a gift.
Oh.
Big, and we mentioned this a little bit later, but I'm thinking of it now because it's that important. Yes, sir.
What about the person who gets the gift?
Great question. It is not income to that person.
It's not.
They don't pay. They are not. There's no such tax. Gifts and
no.
No.
Yeah, it's not income.
Right.
Okay.
Gifts and inheritance, received gifts and received inheritances are specifically excluded from the definition of income under IRC, I think, section 61.
And most people are, I think, contrary because we're so used to virtually everything we receive being taxed.
Right.
That's one of the exceptions.
Yeah.
One of the few.
That's a great question. All right.
We ready to move on?
Yeah.
Okay.
But so you're saying, oh, so I should really not give away more than $14,000 per person per year. Well, hold on, because every person, you have a lifetime exemption amount of $5.43 million. It's actually going to be $5.45 million as of January 1st. That means above and beyond $14,000 per person per year, to anybody, by the way. It could be the hobo on the side of the street. They don't have to be related to. You can give over $5 million worth of gifts, and the IRS sees it as a gift. They say, oh, hey, you made a gift. And you say, you're right, I did, but guess what? I've got an exemption, so I don't have to pay tax on that gift. And they say, you're right, no tax owed. Have a nice day. This is only for federal law. New York State does not have a gift tax. Big, and when we redo this, I'm going to bold this out. This is only a tax rule. This is only a law regarding taxes. It is not a Medicaid rule. So you can't, it's not a good idea to try to get rid of all your stuff, at least without having talked to somebody about it first, for Medicaid purposes by giving $14,000 to each of your kids each year, or $10,000 to each of your kids each year. I've heard that a lot. Somebody will say, oh, well, I'm giving each of my kids $10,000 a year, so the nursing homes don't get it. And I say, well, guess what? If that's within the 5 years of you applying for nursing home Medicaid, they're still going to get it. This is a tax law alone. And I see a lot of accountants will recommend doing this to try to protect assets, and it's not a thing.
Question, I think.
Yeah, you're saying that the the gift tax wouldn't apply for a nursing home? If you give a certain amount of money away?
What I'm saying is,
I understand what you said.
yeah.
You try to give all your money away, that brings a red flag.
That's correct.
For Medicaid, yeah.
For Medicaid,
exactly,
it will.
Yep.
So even though you did it, say $14,000 per beneficiary. Let's say you have 3 children. You each gave them $14,000. You know, that's a fair amount of money you're passing every year. That's not subject to gift tax. But if you did that over 3 years, and that's, you know, say $120,000 you've given away total, and you need a nursing home within the next 5 years, that's going to come back to bite you in the rear end.
So what would be the recourse there? What would be done? The money's already given away.
We're going to cover that after the break. We're going to talk about the Medicaid rules and gifting and how that affects that.
How about the state tax on a gift, the federal? There's no charge for that, but what about the state?
Look at that.
State,
Next slide.
Huh?
No gift tax in New York State.
Oh, no
There you go. Good question. We're a slide away from
no
it.
gift tax, but the gift that you gave for the federal, does that come back into the state somehow?
Only temporarily till 2019 would a lifetime gift affect your estate tax liability under New York law if you die before January of 2019. So the real answer is very minimal impact on gifts under New York state law.
Yeah, probably
Any
not.
gifts of any amount?
Any amount.
Right.
So not subject to that?
Not, there's no, yeah. Now again, the Medicaid rule is a whole different rule, and that is very much a New York state enforced rule, even though it's under federal law too.
Unless you are absolute, honest to God, intent in giving the gift is to have see that person enjoy it during their lifetime, there is virtually no reason to do really large lifetime gifts directly to whatever beneficiary we're talking about. If you're trying to accomplish some sort of asset protection goal, then there are better ways to do it. We're going to talk about them.
Yep. Now, as far as the numbers go, as Austin mentioned, while we're at a 5.43 million exemption come January, a month from now, we're going to be at 5.5 million. So they're going up 5,450,000.
Right.
It's only increasing by $20,000 next year.
Not a lot
It's
this year.
tied to inflation. The gift tax rate, which started, you know, for years it was $10,000 per person, and it's been subject to inflation increases for a number of years. Essentially what happens is the government increases it only in $1,000 increments, and we haven't quite hit that inflation level yet to bring us up to $15,000. So in 2016, once again, we will have a $14,000 annual gift exemption under federal law. The tax rate for amounts over the 5.43 million for those relatively few people who have larger enough estates would be 40%. So it's a big rate, even though the exemption is quite large.
Does anybody have a guess how many estates actually have to pay federal, had to pay federal estate tax? I'm using 2013 numbers, but do you have any guess? What percentage? What percentage of people that died in 2013?
30%.
Much lower.
Yeah.
Yeah. So we're talking about basically how many people, what percentage of people who died in 2013, had more
Over
than
$5
$5
million
million,
estates.
roughly?
Yeah.
You have any
New York
guess?
State? You're asking
No,
New York
across
State
the
or federal?
country.
Across the country. What percentage? 30% was way too high.
Less than 30 in the whole country?
Lower. Lower than 10%. Lower than 5.
Oh, come on.
Keep going.
How did they do that? 2?
3.
Lower than 3.
2.
Lower than 2.
1.5.
I'll get you.
1.8.
1/3%.
Wow.
1/3% of Americans actually had taxable estates for federal
Well,
level.
think about it. How many people
they
have
do?
over $5 million? Not that many.
Well, they figured it out.
Yeah.
Well,
because they had to file a tax return, so.
About the melting away the middle class, we're getting
Right.
the wealthy and poor people.
Oh, you're right. The whole
falling into
income,
the working poor.
right? The inequality issue is true, but we still, even though the people at the top have a huge amount of the wealth,
do.
they're really few in numbers, frankly, and that's why only
There's not a lot of
0.3% in 2013 had federal income tax, estate tax implications, frankly.
And
Trump won't fall on that.
Yeah. So that's why we said earlier that the estate tax exemption amounts having increases they have has really taken estate taxes out of the hands or out of the impact of a significant number of our population. Now, the ones who it affects are, a lot of people own businesses that may be worth multiple $1 million, and certainly people have a fair amount of wealth to begin with. New York, for years, had only $1 million per person exemption, and that was in effect until last year. And that created a problem. As our federal exemption was increasing, the state-to-state tax exemption stayed $1 million. So for that relatively few percent of our population that had federal state tax obligations or implications, many more people were being subject to New York state estate tax. While there are relatively few people who have $5 million states, there are quite a few people that have $2 million states, right? And so we had many people paying New York state estate tax. So finally, in light or in response to the concern that wealthier New Yorkers were abandoning the state, not only because of high income tax rates and other taxes, but primarily because of estate tax issues, they're going to Florida, for example, or the Carolinas that don't have a separate estate tax. In April 2014, just a little less than 2 years ago now, the New York State Legislature and passed into law and the government signed into law an increase in the New York State estate tax. So we see that in today's numbers, or actually through March of this year, the estate tax exemption was just over $2 million per person. Beginning April 1st of this year, it went all the way up to $3.125 million. Next year, next April, so it's only about 4 months away now, we're going to shoot up to $4.1875 million. A year after that, we're going up to $5.25 exemption. And then on January 1st, 2019, it's on the slide, well, actually it is, subsequent years, New York State estate tax exemption will be indexed to inflation to match the federal exemption. So if in 2019 the federal exemption is $5.75 million per person, the New York State estate tax exemption will be the identical amount.
So, I'm sorry, by 2019?
January 1st, 2019 is
It will
when we
match
have
the
the
federal.
So
we have the reunification of the federal and state estate tax.
As long as you live until 2019, you have to have over $5 million to have any kind of estate tax implications, or probably 11, 12 million if you're married.
Married couple. So while we've had this sort of dealing with the New York State estate tax as a separate concern for a long time, it's certainly becoming less and less of a concern. Now, a few states, New Jersey, Pennsylvania, still have lower threshold amounts. So for people residing in those states, we do have that same concern. But New Yorkers, thankfully, again, except for the very super wealthy, it's not a big issue. Yes, sir?
Is real estate counted in your,
Oh yeah.
in other words, not only cash and bank accounts and stocks?
Yes.
Anything of value.
But if you own a couple of buildings, the same thing, that's all added up.
Same
Yeah.
thing if you own a business. You don't know what it's worth, so you got to get after your death, they have an appraiser that has to be hired by the estate to appraise the value of your business, and that will get put into value. Your IRAs and 401ks, that's part of your estate. Life insurance that you own, or have what is known as an incident of ownership, typically ownership, will count in your estate. You could have a term insurance policy for $2 million. Doesn't do you any good during your lifetime. And if you have, say, $4 million of other assets, you die owning that $2 million term life insurance policy, voila, you have a $6 million estate. You've gone from a non-taxable estate to a taxable estate just by virtue of having that $2 million term life insurance policy.
That's another little legal dance move that the government did. So for pretty much every other kind of asset, the way they value it is what it was worth the instant before you die. For life insurance, for term life insurance, what it's worth the instant before you die is nothing, because there's no cash value. For cash value life insurance, what it's worth the instant before you die is the cash value. But the government said, oh, well, we're going to make it the face value. Just forget we said that about it, everything else.
That's right.
It's
Face value of both?
of any life
Cash value on
insurance,
the
yep.
term?
Yep.
Really, at the moment of death, at death.
Just
Yeah.
whatever the face
The value
value,
is.
whatever the death
Regardless
benefit,
of the
life
cash
insurance is.
value?
Regardless of cash value.
Right.
Yep. Just a brief history. The estate tax exemption, it's increased again starting in 2000. It went from $1 million to $2 million, and then it stayed that way till 2009 when it went to $3.5 million. 2010, the year George Steinbrenner died, he had 1 year of no exemption, or no estate tax federally, so he was able to pass his estate without being subject to estate tax.
George Steinbrenner had the best estate tax plan of all, which was to die in 2010.
Right. Then it was reinstituted because without further congressional action, this unlimited amount was going to go back to the $1 million limit that we saw in 2000. That was called the sunset law, sunset provision, I should say. So Congress did not want that to occur, so they compromised with the president, one of the few things there's been compromise of in the last 8 years, I think, to institute a then $5 million exemption with inflation built in. And that's where we are today at the 5.43 exemption. There's no more sunset law. This law will remain in effect forever unless Congress acts again, which they certainly can, but there is no automatic repeal of the law as there would have been in 2010. So we have a concept of portability, which was enacted under the theory by Congress years ago. This is going back in 2010 when the first compromise law went into effect. Historically, the only way each spouse could take advantage of those exemption amounts, whether it was $1 million or $2 million, whatever is in effect at the time of death, was that the first to die spouse's assets had to be parked into a trust, what we call a credit shelter trust, or in our practice we call a family trust.
Millionaires had to do basic trust planning.
Right.
Yeah.
If instead the assets passed by survivorship or other operation of law to a surviving spouse, or even under a will or trust that said it goes directly to my surviving spouse, the exemption amount of the first spouse to die disappeared. So Congress didn't think that was fair. There was complaints apparently out there. I don't know who, but people were complaining. And so they passed a law that said spouses, you can now, the surviving spouse, can utilize the exemption amount of the first to die even if the surviving spouse receives that assets directly to him or her. And that's what the concept of portability is. So portability on its face has some value, and it's certainly the default for people who haven't done any planning, even wealthy people. Yeah, they can use portability, but it's not really a strategy to rely upon for a number of reasons. One is New York State hasn't adopted, and most states who have a separate estate tax haven't adopted portability, and therefore, even though you could avoid a federal estate tax by just passing assets directly to a surviving spouse, failing to park the assets in some form of trust can cause significant state estate tax liability. On the high end, we're almost talking $300,000 in New York. The other thing is by passing assets into a trust for the benefit of a spouse, rather than having the assets go directly to the surviving spouse, it allows us to do some more competent and complete income tax planning. We're going to talk about it in a minute. I'll let Austin cover that piece on capital gains taxes and how our shift has really gone from estate tax planning, because it affects so few people today, to more of the income tax planning benefits of doing good estate planning. So why don't we shift into that piece on capital gains taxes?
So as we've sort of laid out, because of how much money you're able to pass to the next generation or to a non-spousal beneficiary, being millions of dollars, estate tax planning is just not relevant for literally 99.7% of people, right? What is relevant to a lot of people, especially when we talk about people wanting to avoid, long-term care costs, so they're giving assets away without talking to us first, is the capital gains tax. Capital gains tax can affect you quite a bit, and here's why. So just so we're all on the same page, what capital gains tax is let's say I buy, it goes for anything that increases in value. So real estate, stock, something like that. Just for simplicity, I'm going to talk about stock. So let's say I buy some stock at $5 a share. And I hung on to it for a while, and it increases to $15 a share. That $10 increase, that's capital gains income. And when I sell the stock, I got to report that as income and pay the tax on it, which is like 28% now. It's a lot. Second scenario, so I buy this stock at $5 a share, and it increases to $15 a share. Then let's say I give it to Rich. I don't have to pay tax at that point, but when Rich sells it, he'll have to pay the tax on that capital gains that's in that stock.
Let's assume a third. That's like $5 or $3 in tax on a $10 gain.
Exactly.
Almost.
This can be real, especially when we're talking about $200,000. We're talking about a house or something. Third scenario, and here's where you're going to see where the rubber really meets the road. I buy it at $5 a share, it increases to $15. Then, because of my death, it goes to Rich. Rich turns around and sells it. How much tax does he pay?
On
Zip.
everything he sold, nothing?
Zip.
Wow.
What happens is it's called that's what they call a step up in basis. When I buy something for $5, that's my basis, that $5. And then the tax is whatever it's worth now minus the basis. Upon my death, that basis goes from 5 to whatever the value is upon my death. It's stepped up. So when Rich turns around and sells it, it's 15 minus 15, 0 taxable income.
So that's the wipe out of the tax, right?
It just, you don't have to pay. And so, and you can see where this would matter. So say, and this happens, I probably say on a monthly basis now, honestly. I get a phone call where, well, I'm concerned about a nursing home getting my house. I say, fair enough. I mean, that's part of what I help with. I want to give it to my kids. Slow down. You bought your house in 1965 for $15,000. It's worth, just for math's sake, let's say $215,000 now. Now, you have a capital gains exemption on your primary residence, so whatever. But let's say you give it to your kids. They're not living there. When they sell it, they're going to have to pay a third of the increase in value. So a third of $200,000, they're going to have to pay that in taxes. That's a lot of money. And yeah, you might have saved, and that might not be, like say the whole house then didn't go to long-term care. Well, you've won a little bit. But if we could do it in such a way where it's protected against long-term care, and you get this step up in basis where they're not paying that extra tax, that's the way you're going to want to do it.
How do you do that?
We'll talk about it in a minute.
So a lesson about taxes is that an experienced and knowledgeable attorney will tell you about whether you need tax planning, but a counseling-oriented attorney will spend time to learn about you and your family so that the tax tail doesn't wag the dog, such that we don't overlook the personal planning issues about who you really want to get your stuff and how you want them to get it. Because we can solve tax issues and end up still with a terrible result where the new husband ends up with the property or your son's former wife ends up with the property. And we don't want that to happen. We want to solve the tax issues, but also make sure the personal planning objectives are met as well.
Right. We end with that for a very specific, or not end, but we end that segment with that for a very specific reason. We spent a while now kind of nerding out on taxes, right? But at the end of the day, it's the personal goals that are going to drive the planning. We're just going to do that in a way where you're not paying more taxes than you have to.
Right.